Did you know that you can transfer certain assets directly to your loved ones without going through probate, simply by naming them as beneficiaries? Most people don't know it, but some of your most valuable assets in your estate might never go through your will, trust, or even the courts. But there are some real big complications and some pitfalls. You're going to want to stay towards the end because we're going to talk about the pitfalls at the end of the video. I'm Elijah Keys, certified specialist estate planning attorney. That means I'm board certified, like a doctor's board certified, except that I do estate plans. I've done more than 3,000 estate plans, and I want to share with you some things about beneficiary designations. If you've been following this series, you probably know Laura and James are a married couple in San Jose with 2 children. Let's pretend that James has a life insurance policy, a retirement account, and a brokerage account. All of them have beneficiary designations. He named Laura as the primary beneficiary and the kids as backup beneficiaries. Or so he thought. He told the bank that. When James passes away, will everything go to Laura? Will the kids get anything if she dies first? What if James never updated his beneficiaries? Let's unpack what California families need to know. So what are beneficiary designations? A beneficiary designation, or a designation meaning naming, so naming a beneficiary to an account, is a way to choose a beneficiary or another person to receive an asset when you die directly without going through probate or your trust. This works because of the law of contracts. If you sign a contract with a bank, you can give them permission to give your things away when you die. That is a beneficiary designation. They're typically used for life insurance, retirement accounts like a 401k, an IRA, profit sharing plan, maybe 403b. They're used for pay on death or transfer on death accounts. That means a bank account. They're used for brokerage accounts and investment accounts, and sometimes even annuities. Once you pass, the company or custodian pays the named beneficiary. It bypasses your will, bypasses the trust, bypasses the courts. Beneficiary designations are generally easy to set up. They avoid probate. They can be fast and direct, and there's oftentimes no legal fees required. In James' case, Laura can access the life insurance and IRA quickly to cover funeral costs, mortgage payments, daily expenses without waiting on courts. But there is paperwork. The thing to remember about beneficiary designations is that the bank or insurance company or financial institution has a requirement to protect your things. They protect James's things. No one is allowed to get into James's account without his permission. If he's died, we need to prove that he's died. How do we do that? We do that with a certified copy of the death certificate that oftentimes is given about 3 weeks after death, but I've seen them issued up to 2 or 3 months later if there are complications with determining what the cause of death is. If someone died under suspicious circumstances, you're not going to get a final death certificate until the coroner has done a final investigation. Well, what do? Laura, if James passes away, takes a certified copy of his death certificate to the life insurance company. That takes 3 weeks to get that certificate. She provides that to the company that gives her a beneficiary packet if she was properly named as a beneficiary. She fills out the packet, she submits the packet, the life insurance company gives her the money. How long does that take? Generally takes about 5 to 10 weeks. Why so long? The answer is that you first have to get a death certificate, 3 weeks minimum. Then you have to give it to the life insurance company. They don't receive it right away. They have their own processes. Then they give you a beneficiary packet. You have to fill it out. It's confusing, it's long, it's difficult. Then you fill it out, you give it back to the insurance company. They take their normal 3 to 5 business days to process. Then they cut you a check a week later. That seems like it takes a long time. Yeah, it does. The life insurance company has a requirement to prove that you are the right person. They have a requirement to prove that James is dead. They have a requirement to prove that you submitted your paperwork correctly. Why? If they don't, they pay twice. Let me say that again. If the bank makes a mistake, they pay twice. If James has an account with Chase Bank, for example, not saying that Chase Bank is bad, Chase Bank is just fine. If James has an account with Chase Bank and names a beneficiary and there's some sort of error at Chase, Chase pays both beneficiaries. So they have a requirement to make sure that it's right. So there will be very strict controls to prevent Jackson Life Insurance Company or Chase Bank from actually paying the account twice. This is where things get messy. 5 ways that things can get messy. And let's talk about all 5. The 5th one is kind of weird. What if there's outdated beneficiaries? What if James named Laura years ago and she died first? If you didn't name a contingent beneficiary or backup, the account goes through probate, even though it had a beneficiary named. Why? Because the beneficiary died. So it's quite often that someone comes to us and says, hey, I have an account. When did you set up the account? 30 years ago. When did you set the beneficiaries? 30 years ago. What happened in between? Everybody's dead. then there are no beneficiaries. You cannot give a beneficiary designated account to a dead person. It doesn't work. What happens if the first person dies but the second person is still living? Then they get the account. You can name multiple beneficiaries in a row. There's a primary, contingent, meaning backup, secondary backup, third backup called tertiary contingent beneficiary. All these legal words, they can be translated into English. It means third backup beneficiary. The second problem with beneficiary designations is that they might be inconsistent with your estate plan. Let's say that James and Laura created an estate plan and they want to give everything equally to their kids, Maya and Leo. Well, what happens if they only name Maya as a beneficiary of one account and they name Leo as a beneficiary of another account, and they forget and they spend down account number 2? If you have 2 IRAs, you can draw from each IRA individually or one IRA alone. What if they drew from one IRA and they drew down Leo's IRA? Well, at that point, Maya gets a larger share than they would have wanted, and Leo gets nothing. The right way to do beneficiary designations is to view it not just over the account, but view it in connection with your entire estate plan. Your account does not live in isolation in your life. It's part of your overall assets, it's part of your overall plan, it's part of your overall holdings, therefore it should be part of your overall distribution. You should plan accordingly. So number 3 is minors. What if James and Laura named their children as beneficiaries, but one of them is a minor? This is a huge issue. A minor, meaning someone who is under the age of 18, is not allowed to receive money from a bank. They're not allowed. They must have someone as an in-between person. Now, an in-between person just means someone who will hold the money for them. There's 3 types. The first type of in-between person is a custodian. A custodian is named on the beneficiary designation. So James and Laura named Maya as a beneficiary of a bank account. She is 16. They name Laura's brother, Adam. Adam, who is an adult, can be the custodian for Maya. How long can Adam hold the account? The custodian arrangement can be created to hold the account for when Maya is 18 until she's 21, anywhere in there. But the maximum age is 21. So at the age 21, the account must go to Maya at that point because the custodianship is no longer valid. The second type of in-between person is called a guardian. A guardian is a court-appointed representative. This is where things get really tough. What if James died and named Maya as a beneficiary, but Laura was living? Laura has to become the court-appointed guardian. What if Laura and James both die? Name Adam, that's Laura's brother, as the person who is supposed to control Maya's money and accounts, but forget about this one account. Adam becomes the guardian for Maya. A guardian is appointed by a judge, and we have to go through a mini living probate court proceeding. We've talked about probate in other videos. You can certainly see them on our channel. But the guardian must control things for the minor, and the guardian is required to tell the judge every penny that's spent for the purposes of Maya's care. Additionally, Maya's address, her age, her mental condition, any illnesses that she has, any problems that she has in school, whether she's good with money or not, are all disclosed publicly because a guardianship is public. The amount of money that is left in that guardianship is then given to her at 18, and the entire world gets to know how much money she's getting and her address. It's absolutely horrible, but that's the way that the law works. When Maya is 18, she is now an adult, the guardianship terminates, and Adam must give her all the money. The third type of in-between person is the trustee of a trust, and we're going to talk about that at the end of this video. The fourth way that this gets messy is if all beneficiaries are deceased or unable to receive, the account may go through probate anyway. So if you set up beneficiaries and all the beneficiaries can't receive, then the account goes through probate. The fifth way that this gets messy is between spouses. The reason why I say that is that spouses oftentimes want to give accounts to each other and then they want to get the account to another person. And a beneficiary designation, if you didn't watch our original video, beneficiary designation passes the account proceeds to the beneficiary. It does not pass the account. It passes the proceeds. If James sets up a bank account and names Laura as his first beneficiary and names Maya and Leo as the next beneficiaries, the account does not transfer to Laura. The beneficiaries are left on the original account, and the account proceeds, the money in that account, the contents of the account pass to Laura. They go into a new bank account. The old bank account no longer controls. Laura must now designate new beneficiaries. What if she can't? What if she forgets? Then that account goes through probate, because there is no other beneficiary. Once the first beneficiary triggers, all other beneficiaries are wiped away. So who controls it? Unlike joint ownership, beneficiary designations don't give anyone access while you're alive. That's great protection, but it also means that you have to review them regularly and make sure that they match your overall estate plan. Also, beneficiary designations override your trust or your will. If you said split everything equally in your trust, but you only named one child over an IRA, who gets it? Only that child. It's important to make sure that they're updated and coordinated with your estate plan. When do you use them? Beneficiary designations are great when you want fast access to funds for loved ones. Fast in the law doesn't always mean as quick as you want. It means generally 5 weeks minimum. Second way to use them is if you're naming a spouse or adult child who is financially responsible. In a trust or a will, you can set up controls that allow the trustee or the court representative to restrict money going to someone if they can't control the money themselves, if they're financially irresponsible. But if they're not, then a beneficiary designation might work well. Or finally, if you have small accounts that you just want to avoid probate. Maybe your accounts are not substantial. I don't want to say not substantial, but in the law, if something is under $180,000, then the courts don't want to deal with it. So beneficiary designation would be a really good idea. This is Elijah in his office. The law changes all the time, and in this situation, the law changed on us. So the number is no longer $184,500. Now the number is $206,000. Not my fault, not your fault. It just is. The law changed this year, 2025. On with the rest of the video. The thing to know is that beneficiary designations work best if they're coordinated with an overall estate plan. They're not the plan itself. They're part of it. Now, we can talk about advanced planning options too, and this is where things get really interesting. Did you know that you can name a trust as the beneficiary of an account? You can create a living trust and make that trust the beneficiary of an account in the future. Maybe you don't want to transfer the account now. Maybe it's a retirement account, and you can't transfer the account to a living trust. Can't do that, shouldn't do that. But you can name the trust as the beneficiary. What happens? What happens is that the trust controls the distribution. This is great for blended families where each spouse owns their own assets. They don't really want to put everything into the name of the other spouse, but they do want something to go to the spouse. But most importantly, they want the remaining assets to go to the children, go to their own children. If James had Maya as his child before he met Laura, maybe he wants his accounts to go to Maya, but he wants Laura to be able to use them first. He could name his trust as the beneficiary of his accounts. And if he did that, he could control the distribution through the trust so that Laura received it for a period of time, and after Laura died, then Maya received the rest. This is really good if James and Laura have children with special needs. For example, if Leo maybe has autism or some other mental illness, they don't want to give money directly to him. If he did, he might be stolen from. Maybe he would lose some really important government assistance. At that point, they can name their living trust as the beneficiary of retirement accounts or a bank account so that Leo can actually participate in them without losing his benefits. This is really good for asset protection. You are not allowed to protect your own assets from creditors or from divorce. You can, however, protect your children from creditors or divorce. You can do that through a living trust. If you designate your trust as the beneficiary of accounts, your child does not receive them, and you're able to add protection to your child in a trust. We're going to do a series on protections that you can add in a trust at a later time. And finally, if you have minor children, you do not want to name minors as beneficiaries of accounts. It's really bad. You cause a guardianship situation. It's no good. Either you need to name a custodian or you need to pass it to a trust. Remember, only 3 ways to pass money to a minor: guardian through a court, custodian through a bank, trustee through a trust. Only 3. It's the only ones. Each of these advanced planning options allows you to use a trust to manage money according to your instructions instead of paying it out directly to beneficiaries. Oftentimes, it's a much better plan. So let's wrap everything up. Beneficiary designations are powerful, but they do need to be reviewed, coordinated, and built into a bigger strategy. Make sure that you understand the effect of all of your assets, and make sure that your beneficiary designations are not everything that you do. Make sure that they're part of it. If you found this video helpful, don't forget to like, subscribe, and share it with someone who you think needs to hear this. Thanks for watching, and follow along so that we can help you develop the keys to your legacy.